What I'd like to talk about today is a recent decision of the Scottish Court involving Sainsbury's, which was a petition for judicial review challenging a decision of Perth and Kinross Council. It's an interesting case, not just for legal reasons, but for the background. Supermarkets are one business which has been doing particularly well in the current market. Their income has been holding up. And as a result of that, there are significant disputes between different supermarket operators to secure sites. And that battleground has changed in Scotland from the big cities to some of the smaller towns. And there's been quite interesting disputes in Kelso and Inverness. And the case of Sainsbury's is to do with a site in Crieff. And I think that's just an interesting hallmark of where the Scottish market is going. The other policy issue that's interesting about the case is that the judge was, to be honest, fairly disparaging about Sainsbury's arguments and held that they really didn't have much substance and probably they had no real title interest to bring the case. Now, Lord Gill, who's the second senior judge in Scotland, has just produced a report on procedure, and he's suggesting that people like Sainsbury's, before they bring cases in the future, will need leave of the court, permission of the court, as in England. And it's interesting to speculate whether Sainsbury's would necessarily have got leave had they had to apply for it in this case. As far as the legal grounds are concerned, the case really concerns whether or not Perth and Kinross Council could put in place certain policies which they had put in place when Sainsbury's were in effect seeking to develop a site different from that which the council were supporting. The arguments really turned on the basis that the council had granted reserved matters approval, that's the second step in applying permission to Sainsbury's, and Sainsbury's argued they couldn't do that on the one hand and then support another site on the other hand. And equally, they argued that as the council had an ownership interest in the site that they were seeking to develop, the council were precluded from using that ownership interest to thwart their development, which is essentially what they argued the council was doing. There were some other legal arguments, much more technical, but that's the significant legal arguments, and the judge really had little difficulty in throwing Sainsbury's case out, and the impression you get is that she really didn't find that the arguments they were putting forward were very well justified. In fact, she referred to their case as having a scattergram approach.